So we're here for about an hour, a little over an hour, to talk about HIPAA. And we'll talk about all the reasons why HIPAA compliance is really important. On the one hand, there's civil and criminal penalties that could be assessed against the practice in the event that HIPAA is not followed. But I think more importantly, your practice can really suffer reputationally if there's a breach, because patients then view you as the practice that isn't safeguarding their protected health information. All right, so what is HIPAA? Health Insurance Portability and Accountability Act, enacted in 1996 by Congress. It's interesting that I find it interesting, Health Insurance Portability and Accountability Act. So Congress enacted this law because there's a lot of concern about the notion that those who are billing insurance have a lot of protected health information. And there were a bunch of breaches that happened, and principally in connection with transmitting information for insurance purposes. So in layman's terms, Congress said we want to protect the privacy and confidentiality of patients' information, and therefore we're going to enact some laws and some regulations that say how to do that. We already talked about the fact that the three main rules are the privacy rule, the security rule, and the breach notification rule. And HIPAA is enforced by the Federal Department of Health and Human Services, Office of Civil Rights. So if you ever open up an envelope or you see something that's addressed from Office of Civil Rights, get it to Yvette. Hopefully you never get one, but if you do, get it to Yvette right away. Okay, so some reasons why, a lot of this is common sense. Why is protecting the confidentiality of patient health information important? Number one, you want to maintain their trust. They are giving you lots of information. They assume it's industry standard that you are going to keep that information confidential, meaning you're not going to disclose it to parties that you have no right to disclose it to. You're only going to disclose it when you get a patient authorization under certain circumstances. The law requires it. As I mentioned, now that this policies and procedures manual exists, it is like any other employment policy. You are obligated to follow it, to understand it, and failure, breach of these policies could result in discipline as an employee. There's monetary and criminal penalties associated with violations, and again, there's potential for negative press and associated lost revenue from a breach of HIPAA. So we're going to spend most of the time today talking about the privacy rule, because I think when most people think HIPAA, that's what they think about. They're not thinking about IT security or what happens in the event of a breach. So the privacy rule, it establishes the standards for safeguarding patients' protected health information. PHI, as the protected health information, PHI, is basically individually identifiable information, so identifiers tied to a patient, and we'll go through a bunch of different examples of PHI. That concerns their payment for care, their treatment, and that's linked to them individually. So some examples of PHI, all the stuff you think about: name, address, birth date, social security number, their email address, fax numbers, account numbers, diagnoses, medical records, all those things when linked with the fact that they were treated at your practice, that equals PHI. So a name itself is not protected health information, but a name associated with the fact that they were treated here converts it into protected health information. So the fact that they're a patient of your practice is protected health information. And then a lot of these other things are pretty common sense, I think. X-rays, medical records, lab results, those things are what you'd think about logically as protected health information, but you need to be thinking about any identifier plus the fact that they're treated here equals protected health information. So when you're dealing with protected health information, the privacy rule says you're limited in the ways that you can disclose that information to third parties. It also, the privacy rule limits the uses internally of protected health information. The rule applies to all employees, contractors, trainees, staff at the practice. So everybody in this room is likely responsible for complying with HIPAA, and that's why you're here. So there are common disclosures, thinking about the disclosures, so the outside versus the inside. Oftentimes the most common disclosure is a patient says, I want a copy of my health information. You don't, that is, the patient is entitled to get a copy of their information. They can just ask for it orally, or you can have them sign a written authorization, but a patient has a right to get their information. Oftentimes, as you know, you'll need to transmit information to another healthcare provider because the patient has asked you to do so, whether it's sending some information back to a primary care provider or to another specialist. That is a permitted disclosure under the treatment exception for HIPAA. And under that exception, you do not need a separate written authorization from patients. But there are a lot of other disclosures. Those are probably the two most common. So patient says, I want my info, or hey, send my info to another healthcare provider. But there are a myriad of other ways in which you might need to disclose information, and we'll talk through those. Generally speaking, under HIPAA, there's this concept of the minimum necessary rule. So HIPAA says when you're disclosing information, you just disclose the minimum amount of information necessary to accomplish the objective. It does not apply when the patient is asking for their own info. They get whatever they need. And it doesn't apply when you're transmitting information to another healthcare provider. They get what the patient asks you to send. But if there are other disclosures you're making, like in response to a subpoena, in response to a court order, disclosing information to family or friends, those are the types of disclosures that you need to think about, okay, why am I disclosing this information to this person? What's been requested? And I want to limit the amount of information, whether it's a provider orally giving information to a family member or the medical records department making a determination about what information to actually send out. You want to limit the amount of information based on the purpose of the disclosure. So I have an example up here. So if you have, your practice in designing access to an electronic health record has to think about who has a need to access the record and why. Certain people might not need the ability to access all PHI, all aspects of the EMR at all times. And so the practice has an obligation to tailor your ability to access accordingly. Now, some people may need to access it all, that's fine. But if there are certain people that just don't have a need to access everything, there should be access controls in place. That's one example of how the minimum necessary rule applies. But as I said, that rule is not applicable to disclosures to the patient, disclosures to other providers. If you're making mandatory reports like abuse and neglect reports, or making disclosures to law enforcement, those don't apply. And again, I know I'm kind of buzzing through things. It's all in the manual. So the privacy rule provides patients with a host of different rights. And as part of this manual, we've now adopted a notice of privacy practices, which every patient will get, whether or not you did or not. There's one now, and that basically what that is it's the notice to the patient of their rights under federal law and how Atlantic Orthopedics is going to guarantee or do their best to satisfy those rights. So some of the rights that patients have under HIPAA are, one, the right to access, copy, or view their own PHI. So a patient can come in and say, I want all my medical records to date. I want this particular record. They can ask for whatever they want. And the practice has to give that to them within 30 days, okay? So if you're getting requests, you should be responding as soon as possible, but HIPAA says 30 days is the outside deadline. Patients also have a right to request amendment of their healthcare information. So if they're looking at their records because they've requested them and they say, hey, you know what, that's not accurate. I want it changed because, as you all know, records get transmitted around. And so if there's an error once, that error can propound and can lead to some adverse effects. So patients have a right to say, hey, that's wrong. I want you to change the information. They have a right to request restrictions on how their information is used. So the most common restriction is, hey, I don't want X family member to have any access to my PHI. I don't want my spouse to have access to my information. I don't want my brother, my sister, whoever to have access to their information. And if they give you that restriction, you have to follow that restriction with some caveats, but the general rule is follow the restriction. They have a right to receive confidential communications. And we'll talk a little bit more about what that means later on. They have a right to request what's called an accounting of disclosures, which is the practice actually provides them with a list of all the different disclosures that have been made of their protected health information, other than for treatment, payment, or healthcare operations. So meaning not all the disclosures that you're making to them or to other providers, but generally to say, hey, was my healthcare information given out to anybody else outside that list? And they have a right to complain to the Office of Civil Rights if they feel like your practice has breached its obligations. And again, all of these rights are explained in detail in the manual. I'm going to say that a lot today, but just want you to get used to the concept that it exists. So if you're in a position where you're being asked to release a patient's protected health information, you should always be asking yourself, is the patient's written authorization requested? Just sear that into your brain. That's the question that you need to be asking yourself. So I'm about to tell you all the reasons when you don't need an authorization. Okay, so you don't need a signed written authorization saying, I, patient, authorize you to disclose. You do not need an authorization if you're disclosing for treatment purposes. So if you're sending out their information to specialists, to other healthcare providers, if the physicians are talking with other physicians related to the patient's care, you don't need the patient's authorization. Hipaa says we don't want to have, as a policy matter, as you can imagine, it would be quite the burden to have to get a signed written authorization every time you're going to talk about the patient's care. Not required. Payment, you don't need a patient's authorization to bill for the care that you provide. So as you're sending information off to Medicare, Medicaid, and to private insurers, you don't need the patient's authorization. In terms of operations, so they call it the TPO exceptions, treatment, payment, and operations. Operationally, if you're going to use certain cases or medical information internally for quality assurance or for care coordination purposes, you do not need the patient's authorization. If there are certain disclosures that are required by law, like reporting suspected cases of abuse or neglect to, say, Child and Family Services or the Office of the Long-Term Care Ombudsman because you suspect elder abuse, you do not need the patient's authorization there. And then Hipaa has this concept of what's called the personal representative. So that's somebody that's authorized to receive protected health information on behalf of the patient. So some common examples of personal representatives would be if somebody's incapacitated and there's a durable power of attorney for healthcare that's been activated, the agent under the power of attorney for healthcare would be deemed the patient's personal representative. Similarly, if there was an incapacitated adult and there was a court-appointed guardian, that person would be a personal representative. If there's a minor child, the parent would be deemed their personal representative. So if you're making disclosures to anybody in those categories, you don't need their authorization or an authorization from the patient to disclose information. There's also occasionally, and I represent healthcare providers of all different types and sizes, occasionally you'll receive court orders for production of information. So sometimes in the context of a personal injury litigation, they're going to be subpoenaing information or you're going to get a court order for information. Under those circumstances, most of the time you don't need consent or authorization from the patient. And if you ever happen to receive a subpoena, a court order, a call from law enforcement requesting any information, please immediately let Yvette know or let Carrie know. They can interface with me and we can walk through the situation to determine whether you should be disclosing information or not. Same with subpoenas. So other than those categories, you're going to need a signed written authorization from the patient to disclose their information. There is a written authorization form in this packet, and the idea would be that you'd let the patient know, hey, I'm happy to disclose this information for X purpose, but the law requires me to have you sign this authorization. You'd get the authorization, you'd put it in your file, and you'd be able to make the disclosure.
At reception a lot, we do have people filling out paperwork for their elderly parents.
Mm-hmm.
marking themselves as the contact person, but there's nothing saying that they have, some of them are power of attorneys,
Mhm.
but the majority of them are not.
Yep.
So in that case, what do you do? Because like the person they're signing for legit can't read the paper or anything, but there's no legal anything saying that they're a guardian or a power of attorney, but they're
Yeah.
marking themselves as the contact person, the person to call, the person that's okay to give information to.
Great question. So the HIPAA regs say that if somebody comes in with someone and the patient appears to have capacity, so it's not like they're completely out of it and don't know what's going on, you can assume that the patient consents to have them involved in that aspect of their care. So, if the person brought them in and the patient brought the family member in and the family member's helping them fill out paperwork, you are allowed to assume that that person is authorized to be involved in their care in terms of helping out and signing forms. The question of them filling themselves in as the contact person is a little dicier, but if the patient doesn't, it could be, one thing you could do is that you could always just ask the patient if they're not able to actually fill out the form, ma'am, are you okay with us listing your daughter, your neighbor as the contact person, and just get their oral consent at that point. Does that make sense? But it's a great question. So for those of you sitting at the front desk, or others taking phone calls, oh, sorry, yes.
What if they have like a cognitive impairment? We have a patient that comes in with Alzheimer's or dementia. We've had a patient come in with the person who was driving him to his appointments, not a family member, not anything. And we just happened to fill the information in on that. That was kind of a sketchy situation in my head. And I wouldn't have disclosed anything to her because that was uncomfortable, but what do you do in that sense?
Yeah, I think you handled the situation correctly. You have to assess on the fly, as you did, what you're supposed to do there. I think having the person fill in the information on the form is not as much of a concern to me as disclosure, which you just kind of drew that line, which is great. I think if they were saying, I want to come in the room with the patient and be part of the appointment, I would probably be seeking, if it's clear the patient lacks capacity, then they really can't consent for that, and I would just say I prefer that you sit in the waiting room and, but again, then it's kind of hard because the person has capacity and they're not going to understand what's going on.
Right.
In an ideal world, there's a durable power of attorney and it's been activated, but we all know we don't live in the ideal world, right? People come in and you have to deal with it on the fly. So in those circumstances, you do the best you can. Try to disclose as little information as you can to said person. Try to assess the nature of the relationship, how they're involved. I would ask, hey, how do you know Sam? Oh, I'm his neighbor. Okay, yeah, and he's been asking me to drive him to appointments and I've been doing it for years. Well, then you might be able to infer, okay, it sounds like Sam may have wanted, John involved in his care. But if it seems a little dicier, then you need to, assess the situation with Yvette or Carrie and try to figure out, okay, how do we want to handle this? How much information do we want to disclose? I know it's not a perfect answer, but the rules, they try to be flexible as much as possible. Does that answer your question?
It does.
Okay, great. Okay, so verification. If anybody gets a call or somebody's asking for information, HIPAA says you have to try to verify that the person is who they say they are. So if it's the patient and they provided you with ID or you just know them because they've been in a number of times, that's fine. But where the rules are more concerned about is if somebody calls or comes in claiming to be somebody that has authorization to get the information, like a spouse or a sibling, you just have to take some reasonable steps to try to confirm who they are. It doesn't have to be really invasive, but just try to get a little bit more information to verify, like, can I see an ID? Or could you tell me the patient's date of birth? Just before you just copy the records and hand them over, you got to do a little due diligence to make sure you know that the person is who they say they are. That's effectively what we're talking about here. Okay, we talked about the personal representative concept. So that would be somebody that's authorized to get information for the patient. Just to run through the list one more time, if you're dealing with adults or emancipated minors, you're looking at the approved personal representatives are agents under a power of attorney, a court-appointed guardian, or a healthcare surrogate. Has anybody in here dealt with the concept of the healthcare surrogate? Yeah. Let me just go over it real quick. So I think it was in 2016, the New Hampshire legislature passed a law that says that if you're an incapacitated adult and you don't have a healthcare power of attorney, then the law actually has they've set out this priority list of folks who will have the ability to serve as your healthcare decision maker. So it basically stands in the place of a healthcare power of attorney. Because at the time they enacted the law, it was something like 75% of adults in New Hampshire had no durable power of attorney. So think of it as like dying without a will. If you die without a will, there's a law that says, and if no will, then to X person, to your kids, and if not, or to your spouse, and if not to your spouse, then to your kids, and if not to your kids, then to your siblings. It's the same thing with regard to healthcare decision-making power. So if somebody comes in and says, well, I'm the appointed surrogate, then there's some information that you need to request from them. Typically, in order to be appointed surrogate, the patient's physician has to actually have appointed said person the surrogate. So you'd just want to ask for some proof, just like you'd be asking for proof with a power of attorney, that that person has the legal power to act as surrogate. But the surrogacy concept is still pretty new in New Hampshire, so I just wanted to let everybody know. And again, I know this is a small subset of patients, those within capacity. Most of your patients probably have capacity, but in case they don't. Now, for deceased patients, occasionally you may be getting requests for of records for those that have passed away. Typically, it's the executor or administrator of their probate estate that has the right to get the information, and you'd be asking them for proof that they actually are, that they have the appointment. And as of 2017, the law changed in New Hampshire, and it now allows what's called the next of kin to get the medical records of the deceased patient. And that can be a spouse, adult child, a parent, but only if they do certain things. So just keep in mind the concept of next of kin if you're ever dealing with the deceased patient or the representative who's looking for information. Okay, release of PHI phone messages. So I'm sure that some of you are calling and leaving messages for patients. This HIPAA basically says you got to try to give the minimum amount of information necessary, as we talked about earlier, to accomplish the objective. So, I came up with a little script here, and I know oftentimes it's, well, we want to give some information so they know why to call us back. But the ideal is that you don't really give much information during the call. So, this is Sally from Atlantic Orthopedics calling for John Doe. Please call me back at your earliest convenience at X number. Thank you. If it's an appointment reminder, that's okay. But I think what we want to avoid doing is giving lots of detailed information about test results or certainly any other interactions that occurred with the patient and information that you're leaving on a voicemail. You never know who's listening to those voicemails. It could be a shared voicemail between husband and wife or children that are listening. So try to leave as minimum information as possible. Yes?
We do have a form that the patient fills out that says, is it okay, these are my phone numbers, it's okay to leave a detailed message on this number.
Okay.
Can we do that?
Yeah, if the
Okay.
patient consents, absolutely. I'm really glad you brought that up. Certainly, if the patient has signed off on your practices form and consents to it, you're all set. It's where they have not yet consented that you want to be concerned with that. Okay, faxing of information. As I've mentioned, in the Policies and Procedures Manual, there's now a Fax Confidentiality notice. So it's basically a cover sheet that says that the information that you're faxing is confidential. It lists the practice's phone number. It lists the intended recipient. And it basically says, in the event that you are an unintended recipient of this information, please let us know immediately. I can tell you, errant faxes happen all the time. It just happens. So to try to avoid that, you can double check your number before you go ahead and fax the information. Make sure you carefully match up the number you punch into the fax machine with the number that you have in front of you. You can always call ahead too if you know the number of the office that you're calling to, just to check the fax number, and use the fax confidentiality sheet. However, in the event that you do misfax some information, What I recommend immediately is faxing along. If you can find out, and you probably can based on the caller ID, figure out who you sent it to. If you have a phone number for the practice or whoever you're faxing to, call them, let them know that it was, whoever that you're, well, I guess if you faxed it the wrong number, you wouldn't know who it was, so you wouldn't be calling them. You put another fax sheet together, fax it to the same number, the wrong number, saying, I inadvertently faxed you this information. Please call me at this number immediately to confirm you're going to destroy it. And then you do your best. Hopefully you get a call right away. They'd say, don't worry, I shredded it. And you do a little risk analysis to figure out whether that constitutes a breach or not. But if you do have an errant fax, let Yvette know, let Carrie know. It happens, and there are steps you can take to try to resolve it. So I've baked in a few OCR enforcement actions, so Office of Civil Rights, and just to give you a sense of how this can play out if not remedied correctly. So in May 2017, Mount Sinai St. Luke's Hospital in New York, staff mistakenly faxed PHI to the patient's employer. Unfortunately, the fax had some really sensitive information in it: HIV status, STDs, medication, sexual orientation, mental health diagnosis, and physical abuse. Basically the worst fax you can possibly imagine, sending to the wrong number. Patient reported the hospital to Office of Civil Rights. They came in, they did an investigation. They issued a $387,000 fine, and the hospital was forced to enter into a corrective action plan, which basically means here are all the steps from a corporate compliance standpoint we're going to take to ensure this doesn't happen again. And unfortunately, they also had a breach 9 months earlier, very similar, and they had taken no steps to remedy it. So that's what led to the sanctions here. Email. So I understand from talking to Carrie and Yvette that you have a patient portal. Is that what you'd call it? Patient portal that you're emailing information or exchanging information with patients. So that's great. Some practices don't have patient portals. You should be limiting your communications with patients via email through the portal. You don't want to be sending unencrypted PHI to patients through email because there's just no way to guarantee that will remain confidential. If the patient requests that you email them information outside the secure portal, there's a consent form in this packet that discloses some of the risks associated with doing that, but don't do it on your own. If a patient's making that request, bring it to the attention of Yvette or Carrie to talk about that and how you might have that discussion with the patient. Ideally, you'd be sending the information through your portal so there's no risk to the practice. But if ultimately the patient signs off on the consent form, you might opt to do it. But generally speaking, send stuff through the portal, okay? And if you're not sending through the portal, get the consent form signed. You've already started talking about texting, so we just talked about emailing. In terms of texting, it's a similar analysis as Yvette just mentioned. You should not be text messaging PHI with a patient. Unless you have, it sounds like there's no secure text platform. Those are very new. Some hospitals have them, but most private practices do not have secure text platforms. And so I think it sounds like the line in the sand is we're not texting PHI with patients, right? Is that accurate?
That's accurate.
And then amongst each other, be aware of what you are sending to each other as well. Sometimes you're texting about a patient, but there's no actual PHI involved. You're not mentioning name or identifiers or whatever. If there's no identifying information, a bone is a bone is a bone. But I think I want to defer, to your practice administrator about what she wants to do with that. Because some practices, I think, would say, sure, if there's no PHI, a bone isn't going to identify somebody. But if there's somebody's name, it just takes one time to snap the photo and then you see the identifying information. That can be a problem. So the law doesn't cover every single instance. I defer to you on whether that's something you think is an acceptable. You don't have to answer now, whether it's an acceptable or not. So bottom line, we've covered a lot in terms of privacy, and we'll move on to security and breach notification. But if you have questions, ask, okay? Ask Yvette, ask Carrie, get the questions up the line so that you can get your answers. If you get any requests from a patient that you don't know how to answer, check the policies or ask Yvette or Carrie. We want you to have the answers instead of guessing. Some general privacy rule compliance tips. Don't leave paper protected health information out when you're leaving your work area for extended periods of time, when you're going home at night, etc. Don't include patient identifiers, fax cover sheets, and don't include patient identifiers in fax cover sheets, email subject lines, or unsecure text, which you're not supposed to be sending anyway. Be careful about discussing PHI in the hallway. Patients are walking through, they're sitting in the waiting area, voices travel, they can hear things. So just be mindful of what discussions you're having and what information you're disclosing during those conversations. No snooping into the protected health information of people that you might know, okay? Just because somebody's your family member or your neighbor doesn't give you any right to access their information. That being said, if you're part of the care team and have a legitimate basis and need to be accessing information, that's okay. But providers have gotten dinged when they have a staff member or a provider who's snooping around in information of coworkers, of family, of friends, of people of notoriety in the area. Bottom line, unless you have a legitimate medical need to be, and business need to be looking at the info, don't look at it. That's part of the minimum necessary rule. We talked about email, we talked about text message. Carrie tells me that there are shredding bins throughout the practice for paper PHI, so don't throw any paper protected health information in the trash. Get it into the shredding bins. When you're disclosing information to third parties, be mindful of whether the information, the records may have some information that's subject to heightened scrutiny. If you're treating patients with substance use disorders or HIV or mental health conditions, be mindful that there are laws that protect that information on a heightened basis to HIPAA. So in the event that somebody asks you to transmit information to a third party, ask questions about whether, hey, I noticed that this record contains substance use disorder treatment information. Are we allowed to disclose this? And we can get you the answers. Sticky notes are a common issue. Be mindful of leaving sticky notes with patient information on your computer and your workspace, on cards, things like that. Okay, so that's the privacy rule in a nutshell. The security rule we're going to spend less time on because most of you on a day-to-day basis aren't dealing with it all that much. But there still are some key security rule compliance tips that you should be aware of. Security rule, so privacy deals with the privacy of the actual health information. The security rule deals with basically your information technology systems and how you're going to protect the confidentiality of that information. It doesn't apply to paper PHI because you're dealing with electronic protected health information. So this is a lot of things that your IT department and your IT consultants are dealing with, doing periodic updates for your computers, laptops, and your cell phones, protecting against malicious software, monitoring access to PHI, monitoring login attempts on computers, changing passwords frequently, things like that. So in the manual, we talk about password policy and making sure that your password is not 1234, password, those kind of common things. So, they're going to be monitoring what your passwords are, making sure that they, meet certain password standards, that they're changed every 6 months or so, just to make sure that, again, you're just trying to protect the safety and confidentiality of that information. You shouldn't be disclosing your password to others. You shouldn't be displaying your password on a sticky note so you remember it or storing it in a public document. If you're leaving your workstation, log off or lock your computer down, just so that somebody can't walk up and just get right into it. And I think that's as easy as a Control-Alt-Delete. Kind of lock your screen. If you're going to be leaving for a yes.
I know that says for 15 plus minutes, but that should just be log out whenever you leave your workstation.
Log out whenever you leave. Okay. These are part of it. Again, it's the rule says here are some things you should do. The practice has discretion to make a determination about how frequently you do it. So lock versus log out. Lock is just shut your screen down so you'd have to put the password back in to get back in. And if you think that somebody has learned your password, if you feel like it's been impermissibly disclosed, let Yvette or Carrie know right away. So here's another example of an impermissible access through a password. February 2017, Memorial Health in Florida. The EPHI of 115,000 individuals was impermissibly accessed by an employee who used the password of a coworker that had left. The practice did not disable the password when said employee left. So other employee who was still there logs in, impermissibly accesses 115,000 patients worth of information, $5.5 million settlement and corrective action plan. They were dinged for not terminating access and not reviewing the activity of where people were on the system. So this stuff has real implications. Laptops and portable devices. I don't, Carrie, is there, I think some of the providers have some laptops at home, is that right? Anybody else have laptops that they're working on outside the office? Okay. So just, I think you have the ability to sign in through a remote portal, right? So stay in the portal, no downloading of any information to your, to your local drive. If you ever lose your laptop or it's stolen, you believe it's been stolen, let the practice administrator know immediately. The lost laptop, lost cell phone is the most common example and reason for sanctions by OCR. Almost every day there's a new settlement announced with laptop stolen, cell phone stolen, and penalties. So this one, Children's Medical Center in Dallas, $3.2 million fine due to loss of an unencrypted, non-password protected BlackBerry. They still have BlackBerries in 2017, apparently. Okay, and we talked about in terms of your workspace, locking it down or logging off when you leave. You've all probably heard about the danger associated with clicking links embedded in emails. Make sure to check the recipient on the email to make sure it is who you believe them to be. The ransomware and the people doing ransomware and hackers are very skilled at making emails look like it comes from a legitimate recipient. But I think the bottom line is just take the extra minute to confirm the identity of who's sending the email. I rarely click embedded links in emails just for fear of what it might lead to. Be wary of attachments, that kind of thing. So just take the extra beat to evaluate who it's coming from and what it is. So that was the security rule in a nutshell. There's a lot more to it that you all don't need to know about because it's more IT concerns. Breach notification rule, pretty simple. If there's a breach, you need to notify patients. If there's a breach, you need to notify patients no later than 60 days of the date of the breach. So if anybody in this room suspects there might have been a breach, you may have caused it, you suspect there's some sketchy activity going on, let Yvette or Carrie know. We can help evaluate to determine whether it actually was a breach. If it was a breach, then if there's been a breach, you have an obligation to notify the patients in writing within 60 days, describe what happened and what steps you're taking to mitigate against a risk for them. So that can be an errant fax, that can be disclosed to somebody you weren't supposed to disclose to, stolen laptop, hacking activity in the system, emailing it to the wrong person, and more. So there's a lot of different types of breaches, right? There's the accidental breach, there's the intentional breach. They're all breaches, but how you respond to them and how you characterize the notice to patients and the steps you take to ameliorate the harm makes a world of a difference. I think it's worth mentioning that intentional breaches, so taking information for personal use, disclosing it for whatever reason without permission, can lead to individual criminal and civil penalties. There's actually just a big case that came out for an OBGYN in Massachusetts that got convicted criminally for allowing a pharmaceutical sales rep to have access to her EMR in order to get data that they then could use to market to patients. So it seems common sense, right? But this woman is facing up to 15 years in jail, $500,000 in penalties. That's an individual criminal sanction. So there are some real implications here. So as we just said, if there's ever a suspected breach, let Yvette and Carrie know, and they can help assess it. If the breach involves less than 500 patients, you have an obligation to notify the patients in writing within 60 days. You do not have to report it to the media. You don't have to immediately report it to the federal government. But if unfortunately the breach involves 501 or more patients, then you do have an obligation to notify what they call a prominent media outlet to get the word out, which is, you don't want to be in that spot. And then you also have to notify the federal government right away, who likely will come in and do an audit to figure out what happened. So this is an example of what happens when you don't notify patients in the time you're supposed to. So as I mentioned, you have to notify them within 60 days. Presence Health in Chicago, January 2017, hospital discovers a breach, fails to disclose the breach to patients for 104 days instead of 60 days. So OCR, trying to send a message, dings them for every single day that they were late. So there's 44 violations for notifying patients late, 44 violations for notifying HHS late, and 44 separate violations for notifying the media outlet late. So that results in a $475,000 settlement and corrective action plan. So these deadlines mean something. That's why it's so utterly important that if you suspect anything has gone wrong, there's been a breach, a suspected incident, let your practice administrator know. Briefly, business associates. A business associate is a contractor of your company that needs protected health information to do its job for the company. So if you have like a billing company, you need to be transmitting protected health information to them in order to allow them to do your work. If you have a staffing company, they're going to get PHI. The bottom line is you need a business associate agreement. It's a separate contract to be handled through administration. But if you're ever having questions about a new contractor that's come on board, just keep in mind the business associate concept. And once a contractor is a business associate, then you can freely exchange information with them. April 2017, here's another enforcement action where a business associate storage company did not have a business associate agreement, $31,000 settlement just for failure to have the contract. So again, these requirements mean something. There's a lot of different penalties associated with non-compliance from HIPAA. You can have monetary fines. You can see the numbers up here. You can have criminal penalties, involve jail time. It's serious stuff. And in addition to all the penalties that can be imposed by the government, as I mentioned at the start of the presentation, because these are policies and procedures of the place that you work, failure to comply with those policies and procedures could lead to discipline, employment discipline, including and maybe including termination. So some general takeaways from the privacy rule, security rule, breach notification, and I'll leave plenty of time for questions, is familiarize yourself with the manual. If you have questions, you can start here. Otherwise, get the questions up the chain. As we talked about ad nauseum, if you think anything's gone wrong in terms of breaches, etc., let Yvette and Carrie know. Start with Yvette. If she's not available, go to Carrie, and they can help evaluate. Use the forms that are in this packet and that the practice has published, like the written authorization form, notice of privacy practices form, consent to electronic communications form. Use those forms every time. Those are going to protect you. They're going to be in your file. You're going to know the form of them. And you're never going to be forced to recreate, well, I had the conversation with the patient, they told me, and I had a note, but the note's not clear. It just gets a little dicey. Question?
Is the associates agreement form in there?
It is. Yeah, there's a form business associates agreement in this packet as well. And the idea is to use that form every time. Sometimes contractors will ask that you use their form, and Yvette will have to make a determination about whether to use their form or not. What's nice about the form that we've put together for your practice is there are protections for you in the event that the business associate actually doesn't do what they're supposed to do. The law on business associates is contractors are required to hold the confidence of information in the same manner as you are. So if you transmit anything to them, they are bound in the same respect as Atlantic Orthopedics. Think about, as we talked about, no snooping in information of people that you might know, but also think about not snooping into your own information. If you're a patient of the practice, you shouldn't be looking at your own info because you don't have a legitimate business or healthcare need to be looking at that info. You can request that the information be given to you, but you need to do that through the approved channels. This is obvious, but no posting of any patient PHI on social media. I know sometimes it can be totally innocent, but there should never be a context where you're at work and you're posting any information about any of your patients on social media. There are a lot of settlements that come down from social media issues. Sometimes it's as innocent as snapping the photo, the selfie with your favorite patient, John, and then all of a sudden John is reporting you to OCR. So there's really no room for social patient information on social media. No emailing of PHI to your home computers. Promptly report any stolen or lost devices to the extent that applies to you. Don't give your password to anybody. It's yours. You should be using it to log in. And that's pretty much the overview. Now I'm sure there's a bunch of questions, some have already come up. Happy to talk about anything. Really open season, we'll answer any of your questions. Yes?
When people check in and they don't have their insurance cards and they have pictures, sometimes they'll ask if they can email those pictures of the insurance cards to us
Yep.
because they don't have the physical one.
Mm-hmm.
Is that or is it okay because it's their
There,
email
yes.
to us?
Them emailing you is fine because they're
Okay.
making the determination that they want to email. Just be careful about when you're responding because that might be embedded within the email. If there's a way, if you're just going to respond to say received, that you delete say they emailed you an image, an attachment, just delete the attachment and say
Okay.
received, thank you very much,
Okay.
and leave it at that. But yeah, you can't control what patients email to you. You just have to be concerned about what is outgoing from here.
Okay.
Any other questions?
I have a question.
Yes.
Not here, but you say everybody's entitled to their own medical records. Now, I've come across some practices saying if you don't pay this amount, you can't have your records. Is that legal?
No, it is absolutely not legal. So you can charge a fee for records. You're allowed to do that. New Hampshire law says you can charge a minimum, it's either $15 or 50 cents per page, whichever is greater. So the practice can absolutely charge for paper medical records, but it can't. You can't say to the patient, you haven't paid for your care yet, and thus we're not giving you your medical records. You can't hold the records hostage because they haven't paid for their care. If they don't want to pay the medical record fee, that is a legitimate basis also for not turning records over. But you can't hold records hostage because they haven't paid for their care. And you can charge a legitimate fee. Does that answer your question?
Yeah, because I've had some transfer one records to another doctor's office, and if you don't pay this fee, it ain't happening.
Right. So there's different rules regarding whether they're asking you to transfer electronic records versus paper records. You can charge a fee in either circumstance, and it's just a matter of, from an optics standpoint, whether you as a practice want to say, well, you haven't paid the $15 fee, and therefore we're not giving you your records or not.
And they can do that.
It just depends on what the practice's position is on that particular issue. But OCR has come out saying you can't not give the patient records upon request because they haven't paid for their care. You can't hold them hostage to get paid. Good question. Well, thanks everybody for your attention. I really appreciate it. And please check out the manual, check out the handout, and ask any questions that you have. I'm sure you probably have some thoughts after today. Thanks again.